All right. I want to welcome everyone to the House Judiciary Committee. Sorry we're running a minute late today. We'll begin with a prayer. Please join me. Dear Heavenly Father, we thank you for this opportunity to work together, work on these important issues facing the state. We ask you to please be with the people of Ukraine as they're going through this invasion right now. Amen. All right. So we got 4 bills on the calendar today. And one of our members I know is out with a conflict. We got, let's see. We got Representative Yurda with us, so we'll call HB 1396 first. Representative, if you'd like to come forward to the witness chair right here, and you're welcome to bring up any witnesses that are with you as well who want to speak on the bill. Hello. Yeah, if y'all just want to come on up and have a seat right here, and that's perfect. Excellent. All right, so it looks like we got a the bill is introduced is in the folder, House Bill 1396 LC 441763. And if that's correct, Representative Yurda, please go ahead and present your bill.
Yes, sir. Thank you, Mr. Chairman. I appreciate the opportunity to come before you guys. And yes, I bring House Bill 1396. This would statutorily recognize the Georgia Municipal Courts Clerks Council. They now have a nonprofit, and actually the municipal courts are the largest classes of courts in the state with over 300. But this, them becoming state recognized would basically assist with the municipal courts further bringing professionalism and administration to the courts and best practices. Also, it would aid them in being able to seek grants for municipal court clerk certification program. It would also have an entity that represents the municipal court clerks in the state of Georgia. And they also wish to develop mentoring programs also. I was a mayor for 18 years, and I certainly recognize the value and the importance of municipal court clerks and what they do. And a lot of them wear a lot of hats and have other responsibilities, but you know, I really think this would aid in training and assisting them in better serving the public. They're, like I said, they have a lot of hats to wear, and they have to do a lot in day-to-day operations, and certainly standardizing operations and using best practices would be beneficial to them. And just ask for your favorable consideration, and be glad to entertain any questions. And I'll ask them to speak on behalf of the bill also.
All right. Ms. Collier Tucker, if you'd like to introduce yourself, and then please tell the committee anything you want to share with us.
Great. Thank you. Good afternoon. Representative Yurda has stolen my thunder, but my name is Christy Collier Tucker. I bring you greetings from the progressive city of the city of Union City, but I serve as court administrator and chief clerk there. I also proudly serve as the 2022 president of the Georgia Municipal Court Clerks Council. This afternoon, I come in support of House Bill 1396, which would allow for the creation of the Georgia Municipal Court Clerks Council. GMCC was established in 2006 to provide a collective body to promote education and collaborative efforts in developing best practices for the 389 municipal courts in the state of Georgia. Within those 389 courts, the Judicial Council and Administrative Office of Courts has 686 persons registered in various positions within those courts. 389 of those, of course, serving as chief clerk. As Representative Yurda said, the municipal court courts are the largest class of courts in the state of Georgia. In 2019, pre-pandemic, our courts reported a caseload of 1.1 million cases as seen by court staff. And during the pandemic, we still reported 756,000 cases in 2020. So I'm sure you're asking, why do we want or need to become statutorily created? Well, just like in 2010, when the Georgia Council of Court Administrators was created by now OCGA 15-5-100, we want to seek opportunities to professionalize the organization and the profession. The creation also will allow us the opportunity to seek grant funds and for the better improvement of the courts and the people that we serve for the administration of justice. I'd like to thank Representative Yurtsa, Gillette, Gunter, Barton, and Collins for your support in bringing forward this bill. And with the support of the Georgia Municipal Association, the Institute for Continuing Judicial Education, and the Council of Municipal Court Judges, I, on behalf of the Executive Board and members of the Georgia Municipal Court Clerks Council, ask that you support House Bill 1396. Thank you.
Thank you very much for being here. If you wouldn't mind, if y'all could switch chairs, maybe we can hear from
yeah,
Mr.
absolutely.
James now. And if Ms. Collier Tucker, if you'd please stay close just in case any
Absolutely.
committee members have any questions. Thank you. All right, Ms. James, if you would please just introduce yourself and then tell us anything you want to say.
Yes, sir. My name is Jason James. I serve as the court administrator for the municipal court in Hiram, Georgia. I've been employed by Hiram since 2011, and I've been the chief clerk since 2016. I was voted to the executive board of GMCCC, Georgia Municipal Court Clerks Council, in 2020. Like Ms. Collier said, with 389 municipal courts in the state of Georgia, these courts are as varied and diverse as the good people of our great state. Some municipal courts, like the Municipal Court of Atlanta, operate tirelessly with multiple sessions every day, while smaller cities may hold court as infrequently as once every other month. Despite the diversity in the municipalities, every municipal court must follow the same laws and rules to make sure the court is run properly and in a way that respects the constitutional rights of everyone brought before the court. A properly run municipal court promotes public safety, improves quality of life, and inspires confidence in the city and its leadership. This legislation is a step in the right direction by, one, having a recognized entity that represents the needs of municipal court clerks in this state. Number two, assisting the council, GMCCC, to bring competence and proficiency to the profession of municipal court clerk and assist with standardizing practices across municipal courts in Georgia. And then three, providing aid in seeking grants for the creation of municipal court clerks certificate program. And with that, I just want to thank the city of Hiram, city manager, our mayor, council, and my hardworking staff who are actually in court right now. It was very hard for me to get here today. I really appreciate them. I'd like to thank GMCCC President Christy Tucker for her support and leadership through this process. Thank you to LaShawn Murphy at the Judicial Council, Administrative Office of the Courts, for being a dedicated advocate and resource through this process. And I would sincerely like to thank Representative Joseph Golett. I think we started this back in May, for always taking the time to listen to the needs of his constituents. Also for his assistance in drafting and vetting this legislation with the help of Paul Higbee Jr. at the Office of Legislative Counsel. Thank you to the committee for taking the time to consider this bill, and good afternoon, and God bless the state of Georgia.
Thank you very much. All right, we have a question. Representative Kelly.
Thank you, Mr. Chairman. I had just a couple of questions just about the operation, but Mr. James, thank you for being here. Are we getting any work today out of Judge Plumley?
Yes.
We get some work out of him today as well?
He is working as we
Good,
speak.
good. I know what kind of burden y'all have over there with my good friend Chad. Just to make sure, this is gonna fall under AOC. Is that where it's gonna, the Administrative Office of the Courts, is that the state agency it'll come through?
That's correct.
Okay. And I guess, how are y'all funded now? I guess through y'all's organization?
Just membership.
Okay. Yeah, that was my, thank you. Do we expect an increase in funds from the state, or do we think we'll be able to do it through grants?
We're hoping to do it through grants. We're not requesting any money of the state.
Okay, if it's federal grants?
Yes.
Okay, all right, thank you.
Representative Scoggins.
Yes, just a question. Did y'all talk about any requirement of any mandatory hours and training? Most of these councils that we have worked on require a certain number of hours before they can achieve their certificate. Did y'all talk about that any? I guess that would go to Ms. Tucker.
Yes, we actually have Currently, the state mandates that clerks do 16 hours initially and then 8 years every year after. But we would like to do a certificate program that would be a requirement of at least 90 hours.
Okay,
Yes, to get the certificate. And then we'd like to have levels to that as well, kind of a mastery of certificate kind of thing, so that it'll kind of professionalize and then let there be a gradual step for clerks.
okay. Thank you for your hard work.
Thank you.
Representative Leverett.
Thank you, Mr. Chairman. Thank all y'all for being here today. And thank you for what you do. I represent the city and have acted as solicitor of that city court, and so I know what kind of hard work gets done in municipal courts. Much of it after hours in the evening and after 5, and so I salute you for your dedication to the job. Just to make sure I understand current state. Right now, there is an association, but it is just a nonprofit entity, and is membership mandatory or is it voluntary?
It is not, it's voluntary.
It's voluntary,
Mhm.
but you do some training through that organization.
We do. We work with ICJE to do the facilitating.
Miss
training.
Collier Tucker, if you would come back up to the microphone, we have folks online who are watching. I want to
Okay.
be able to make sure that they can hear.
So yes, we work with ICJE currently to make sure that clerks have the mandated training.
Okay.
Yes,
And that was the question. So there is a mandate in state law already for a certain amount of training.
correct.
So with this act, would you then require membership in the council in order to be a clerk, or require, I guess you already have to complete training to be a clerk anyway.
That is correct. It would really help us in promoting more professionalism. So those 8 hours doesn't get you a whole lot of training. It's usually the same DDS, GCIC things that are, done every year. But this would help us to bring in some other training, and we need to have grant funds to bring that in to establish a certificate program. And that would help us do that.
So it wouldn't necessarily be mandatory training, it would be voluntary training, but it would provide for a higher degree of training in detail. And professional.
Absolutely.
So again, I think you answered this, but currently your membership is not mandatory. Would you anticipate making membership in the council mandatory in order to be a clerk?
Not to be a clerk, but definitely to take advantage of the professionalism programs that we'd like to offer.
Continuing to have.
Correct, yes.
The only reason I was asking is I was wondering if you might also need to tinker with some of the other statutes, but from the way you described it, I don't think you would.
Right.
Would you need to add, and this might be more of a question for Paul, I'm not sure what other councils do in their enabling legislation, but is there any express, or is it viewed to be better to have an express authorization for them to do training or certification?
Off the top of my head, I'm not sure how the other councils do it, but I don't see a need for anything beyond what's in here for what they describe they want to do.
Okay, because I guess currently you're providing the required training as a nonprofit. Certainly you should be able to provide it if you've got council staff.
Absolutely. And I do want to also mention that that's requirement through the state is only for the chief clerk, not the other staff. So as I mentioned, there are over 600 other staff members who don't have to have the requirement necessarily. This would also allow them to participate in the training. Exactly.
Thank you. Thank you so much. Thank you, Mr. Chairman.
Absolutely.
Representative Fleming.
Thank you, Mr. Chairman. Representative Leverett delved into exactly some of the things that I was thinking about, but I just want to clarify that a little further. His question about, do you have to be a member of this new council to be a clerk? And your answer was,
No.
okay, on line 17, it says there is created the Georgia Municipal Court Clerks Council, period. And it further reads, the council shall be composed of the municipal court staff of all municipal courts within the state. So as I read that, just by being a clerk, you are a part of this council by operational law, because you're the staff of a municipal court. And I don't think it's a bad thing. I was trying to figure that out. I was thinking in my mind, you're going from a voluntary organization to a mandatory organization. And I think those two lines right there confirm that. I mean, am I reading? I may be reading that wrong.
I'm sorry, what's the line number again?
Line 17, it says, you know, that we're going to create a Georgia Municipal Clerks Council. And then the next sentence is key at the end of line 17. This council shall be composed of the municipal court staff of all municipal courts within the state. So if just by being a member of a municipal court staff, you are a member of this organization, as I read that by operation of law. Have I got that? I may, if I'm misreading it, someone tell me.
Mr. Higby, if you can help me with that, but I'm not sure that that's.
I would agree with.
Okay.
And I don't necessarily think that's a bad thing, but I was trying to figure out what we were doing here. And I think what we're doing is we're taking a volunteer organization, obviously giving it higher status and organization, but putting it in law, but we're making it a mandatory organization, which I don't necessarily have a problem with, just as long as everybody recognizes that's what we're doing. And if GMA supports you, which you said they
They
did,
do.
they've obviously read this and they got good lawyers, and I'm sure they've thought it through.
Yes. And as well as the Council of Municipal Court Judges as well. Yes.
Thank you.
All right, I don't see any other questions. So we're now in a posture to consider the merits of the bill. All right, there's a motion to pass in a second. Any further discussion, amendments? Hearing none, all those in favor of the bill as presented signify by saying aye. Any opposed? All right, House Bill 1396 is on to committee, and we will have some Rules Committee forums for you here. If you want, Representative Yurda, or you and I can connect at some point later, just whatever you'd prefer. So,
Okay. All right. Thank you.
all
Thank
right.
you.
Thank you very much for being here today. All right, next bill we'll hear is House Bill 1393. Representative Bonner's here with us. If you'd like to come on forward. And whenever you're ready, you can go and present the bill.
All right, thank you, Mr. Chairman, members of the committee. I'm presenting House Bill 1393. I'm working off of LC 441985. And what the bill does is it addresses some provisions under the emergency authority, under emergency judicial authority. And if you look, the part of the bill is on line 10 and 11. It just says that that the ability for a judge to impose or to move forward with a dispossessory proceeding is not included under the judicial emergency authority under code section 38-3-62. One of the what really brought this up is as we all are aware, during the course of the pandemic, there were a number of eviction moratoriums that were put in place. There was one by the CDC that eventually, I believe, went to the Supreme Court. They did not rule on it because it was expiring, so we didn't get a chance to kind of adjudicate that in general. But what we saw over the course of the pandemic was oftentimes these eviction moratoriums in place that were in most cases unnecessary. There were a number of programs where tenants were receiving money for rent that were, for whatever reason, was never making it to the property owner. But this also was a significant impact on those property owners. And it was not really the big institutional investors that had a bunch of multifamily properties or a huge portfolio of single family homes, but it was primarily those smaller investors, those folks that may have one or two investment homes as a part of their retirement plan, that they were not collecting rent because of the moratorium, and they were not getting any relief from their lender. So this was really putting folks in quite a bind. So we sought to address that, and this is what we came up with in the confines of the judicial emergency. So with that, Mr. Chairman, I'll be happy to answer any questions.
All right, so we have a few questions. Representative Wilson.
Thank you, Mr. Chairman. Representative, I just want to be clear, this would exclude dispossessory cases from the judicial emergency.
That's correct.
are there any other cases that we exclude from judicial emergencies that you're aware of?
Not that I'm aware of. I wasn't really, I was not concerned with any other items, but this is the one that I'm not aware of any others.
Yeah, and I did a quick search too, and there aren't any. And I think you bring up a very good point about the squeeze that landlords, in particular, you know, if we want to call them mom and pop landlords, were feeling during the pandemic. But my concern is the event that brings about the judicial emergency indicates a lot bigger problems happening. And I want to draw your attention to the definition for judicial emergency, a few subsections or a few code sections up, 38-3-60. The definition for judicial emergency requires one of three things. One, that an emergency substantially endangers or infringes upon the normal functioning of the judicial system, or the ability of persons to avail themselves of the judicial system, or the ability of litigants or others to have access to the courts or to meet schedules or time deadlines. If one of those three things are happening, then by definition, parties to a dispossessory proceeding are not going to have access to the court. The judicial officer has already determined that they're not going to have access to the court. So how does this not completely upset the apple cart?
Well, understand your concern with the question. And I think, you know, one, if you want to call it a benefit that we've seen through the pandemic is the flexibility of our court system to overcome this. And I know I'm a commercial property manager, so we end up in magistrate court a fair amount. And, you know, our magistrate courts have done a pretty good job on transitioning over to Zoom and really, you know, opening that up as an avenue that I think truly provides, at least at that level, provides a fair shake to everybody. So that's one example of how our courts have been flexible enough to overcome, because as you can imagine, we've got to balance the emergency that's taking place with the ultimate rights of that property owner, right? And so somewhere in that, we need to find that balance. And so I think one of the takeaways from the pandemic is the ability to be somewhat flexible with our court system, at least at that level.
But how do we ensure? I have no doubt that the landlords are going to be able to avail themselves of the dispossessory process. But how do we then protect the rights of the tenants during a judicial emergency?
Well, they have the same availability.
But
right?
they don't, because the judicial officer, in order to declare a judicial emergency, by definition, has had to say, because of other events happening in the broader society, all parties do not have equal access to the court right now. And because of that, we are going to take the incredibly unprecedented stance of putting a pause on all litigation to ensure that we can do it fairly and justly.
Yeah, and so
Right?
my point to that is we've seen what that looks like, and we've seen how we can overcome that to some degree, right? We are not looking at this as something that we, you know, are laying the best plan for. We've actually seen this happen. So I think that we've learned a lot through this. And again, I think the overwhelming interest, at least from my point of view, is in the property owner and the ability to do what I need to do with my property, because essentially you're putting that is put at risk of not only, you know, is basically losing the property because I can't get any kind of judicial relief from this situation. So again, I think it's just a matter of weighing those interests.
Yeah. Mr. Chairman, I'll just finish by saying, I appreciate your honesty, Representative, but I think we've got to ensure that the court is accessible for all parties during the judicial emergency. And by mere fact of it being a judicial emergency, I don't think we can do that.
Right, Representative Evans.
Thank you, Mr. Chairman. Representative, understanding the concern and not trying to minimize the concern of landlords throughout the state, but a lot of things had to go on hold during the judicial emergency that a lot of us would have wanted to see move forward. And so my question is really more from a policy standpoint. What would you tell us to tell the people of Georgia as to why of all the things that we had to put on hold during a judicial emergency, we're going to take away flexibility on just this one thing? For example, how do we tell a victim of crime, I'm sorry, we can't try the person who's killed your children or stolen from your business or any number of crimes. We're suspending grand juries. We're not having bond hearings. We're not moving this forward. But by golly, we're going to kick people out of their homes. How would we explain that?
So understand the question. Thank you for that. And again, I should preface all this saying I'm not an attorney, and I know that I'm presenting to a group of qualified attorneys. So again, using my experience in magistrate court, for instance, which is predominantly where these issues are likely to be heard, right? That is and my understanding is that it is meant to be one of the more accessible courts. For instance, you don't have to have an attorney to represent yourself in magistrate court, correct? I mean, that's my understanding, right? So I think what this does is to get at, okay, and looking in total at the court system and all the things that are part of that judicial process, this is something that we can do, and we've proven that we can do even during an emergency, right? So we have that capability. So I would see this as it's not choosing necessarily one over the other, but this is something that we're doing because it is a more accessible level of the judicial system.
But your assumption of equal accessibility, or this one area where it might be easier for folks to access the court, and Zoom in particular, also assumes a certain level of accessibility and ability to get notice. True?
Well, if they're still in the property, they're getting notice.
Well, but you're assuming a certain level of accessibility to Zoom, at least. True?
That's correct. They would certainly need to have that. But again, I think I would imagine it would be within the purview of a judge that if someone did not have Zoom or a phone at their home, that they would have access, somewhere else.
Well, I think that's my main concern. What you just said is we're taking away in all other areas of the law. We're basically saying judicial emergency, we're tolling deadlines, we're not having grand juries, we're not doing this, we're not doing that. And we do give the judges flexibility. If you can figure out a way to safely have court, if you can figure out a way to get both parties there and have a hearing, you can do it. But in this one area, we're not giving you any discretion. This goes forward no matter what. So your statement right there is exactly my concern, that we are taking away every bit of flexibility that we would otherwise give to our judicial officers in a judicial emergency. And that's my concern.
Understand.
Representative Fleming.
Thank you, Mr. Chairman. I'm still trying to figure out how the court is accessible to some people and not others. If the person filing the case can show up and it's available, the court's available, the person opposing can show up and it's available. You may not have an answer to that because you didn't make that proposal.
That's been my experience, that it's that I've got to show up and I get the same notice that our tenants get.
So other thing I wanted to ask you about, and this is something that I observed rather than was educated on, and I don't know if you can educate me or not. There was a ton of money in my perception for rental assistance out there. In the reports I was hearing is it was not being utilized, that local governments were having to bend over backwards to try to get someone to come get some money to pay their rent. And I couldn't figure that out at first. And then it dawned on me, nobody has to pay their rent. And that's why the rental assistance programs were underutilized. At least that's what it seemed to me. I don't know if you can comment on that or not, or if you experienced that or not.
So I did see some of that. There were a number of issues. There was everything from the ability of that municipality to actually deliver. That's not necessarily a lot of governments are set up for. And so even though they had access to the funds, the mechanics of distributing it, I think, was a challenge. People, I mean, frankly, just people knowing about it was a challenge. And then, unfortunately, in a lot of cases, people just chose not to take advantage of it because they just flat out weren't obligated to pay the rent. And I'm not aware of any of those programs that, where that money went straight to a landlord if they were applying. There may have been some. I was not aware of any. But again, the challenge on the property owner side is that, if that property had a mortgage on it, that lender was not forgiving at all. And so there weren't programs to help with that.
Thank you, Mr. Chairman.
All right. So we have quite a few lights flashing up here. And what I'd like to do is go ahead and refer this bill to subcommittee so that y'all can have plenty of time to hear testimony on this and get all the members' questions answered. Just give a full opportunity to look into this bill. I really appreciate the committee members' interest, and I appreciate your being here, Leader Bonner, to present this so that that can be discussed. Of course, there's several days before crossover day, so there'll be time to hear your bill in subcommittee still this session. So this bill is going to the Gunter subcommittee. And while I'm talking about subcommittees, there's another bill on the calendar, HB 1388. I'm going to refer that one to Chairman Scoggins subcommittee. So I'll just repeat that. HB 1393 will go to Gunter. HB 1388 will go to Scoggins. And thank you very much for
Okay.
being here today.
Thank you.
Appreciate
Appreciate
your
it.
time. All right, very good. So that leaves one bill for us, HB 1383, and Representative Walensky is here. And if you'll hit your button, I'll go and recognize you.
Thank you, Chair. Yeah, you can come to the mic. I presented this bill last committee meeting just for a brief overview and to give everybody time to review it. This is a wonderful cleanup bill by the Georgia Commission on Equal Opportunity. And we have today Alana Cross, the commissioner, chair, what's the word?
Executive Director.
Executive Director. It's been a long, what day is it? It's been a long week already. Commission on Equality Opportunity. So I thank her so much for being here. I could go through the bill again. And if people have questions, happy to take questions, but this is really a long needed cleanup bill. And there's not too many changes. It's a couple of the pages have paragraphs taken out, and those are due to other code sections saying the same thing or it being repetitive in the own bill. So this is just helping with the procedures. And Chair, I'm happy to take questions or let Executive Director Cross speak.
Well, thank you so much. So as I understand it, Director Cross, this is a department bill. It's requested agency legislation. Is that right?
Yes, sir, Mr. Chairman.
All right. And Director, maybe if you would just go ahead and present anything that you want to about House Bill 1383, we'll hear from you now. Thank you.
Good afternoon, Mr. Chairman and members of the committee. Thank you for the opportunity to be here with you all today. I am Alana Cross, the Executive Director of the Georgia Commission on Equal Opportunity, Office of the Governor. Also present here with me today is Jonathan Harris, GCO's Deputy Director, and Mr. Harris will also be available to answer any questions you all may have. I will be very brief with my remarks today. The bill to amend the Georgia Fair Employment Practices Act is essentially an amendment to clean up specific provisions within the act. And the amendment of those specific provisions will allow for procedural and administrative changes that will equate to a more efficient complaint process. And we ask for a favorable consideration of this bill, and we look forward to answering any questions you all may have at this time.
All right. Thank you very much. And Director, I think we've worked together on legislation in past years. Fair to say that there's some cleanup requests and some clarity requirements, particularly with respect to Administrative Practices Act and the involvement there. Is that correct?
Yes, sir, absolutely.
All right. And Assistant Director, is there anything you'd like to add or any specifics you'd like to give the committee about the bill?
Excuse me. The only thing I'd like for consideration would be the recognition of the efficiencies that will be built in with regard to the changes that are proposed. It will allow us to be, as I stated, more efficient, especially with regard to cases that may be connected with regard to those that may need to be amended. So if we get one case in that is attached to another, right now we have to do actually two different investigations. But with regard to if it's allowed to be amended, obviously we can put those together, we can move forward. So that's one of the greatest things that would be attributed to any additional passage of the bill.
Is it fair to say that if somebody is maybe filing an initial claim, he or she may not identify all potential claims, and that once that initial claim is investigated, maybe, well, under existing law, you'd have to dismiss the original petition and then allow for a new petition to be filed. Whereas if this bill passes, that could just be amended to be a new claim or petition. Is that fair?
Actually, we wouldn't actually dismiss it. We would actually still have to investigate the first one and then have to investigate the second one separately. So you could have a situation where you could actually have multiple investigations under one particular act.
Okay. All right, Representative Fleming.
Thank you, Mr. Chairman. I think you just started to get a little into what my question was going to be. Quite often when we talk about rewrites and changes to sections to make them function better, we talk about procedural changes, which most of that seems to be. And then we sometimes ask the question, is there any substantive changes in here? And that's what my question is. As I skim through it and have read it previously when we talked about it, it looks to be procedural. Is there anything substantive change-wise? Does that question of those two definitions make sense to you?
Absolutely.
Absolutely.
Yeah. Is there anything substantive in it?
There is.
It's all procedural.
It's all
Yeah,
procedural.
Okay. Last question, history makers, Alpha Kappa Alpha.
Yes, sir.
Thought that's what the
Today's
pink
AK,
and
today's the
green
capital.
was.
We're happy to be
Yeah,
here.
I thought so, yeah. Saw your pen there. Looks good on
Yes,
you.
thank you.
Thank you, Mr. Chairman.
All right. Any other questions from the committee? All right. Hearing none, I'll hear a motion. This motion do pass. Is there a second? All right. Motion do pass and second on House Bill 1383 LC 365039. Any discussion? Hearing none. All those in favor signify by saying aye. Any opposed? All right, it's on to rules. Well, thank you so much for being
Thank
here.
you for your support,
Director,
Mr. Chairman.
Assistant Director.
Thank
Thank you. All right, very good. Well, those are all the bills that we have on the calendar. I will just tell the committee for scheduling purposes, we have committee this Wednesday at 9 a.m. HB 1389 and HB 1390 scheduled to be heard. The judiciary picture is a week from this Wednesday. Yes, when we're back in session. Yeah, the 9th, I think. So, all right, we'll see everyone Wednesday at 9 a.m. Thank you. We're adjourned.